Hello everyone, how you doing? Welcome to another stream. Today we're going to be looking at court stuff. We're going to be looking at all sorts of contempt and confusion in court. Should be a lot of fun. We have at least one person who showed up drunk to court, which is never a good idea. So this will be fun, spending a couple hours hanging out, watching weird stuff. Good news also. The cough was not the good news, sorry. Today I finished editing the first episode of the Tin Files, which is going to be a very basic YouTube series I'm doing, where I'm going to be looking at conspiracy videos and stuff. Sort of like on live stream, but it's edited. It's easier to digest on YouTube. So I did the first episode of that, and that should be out. I haven't decided if I want to schedule it to go out tomorrow, or if I want to schedule it to go out Monday. So it'll be one or the other. I'm not sure. I haven't decided. I'll show it to Baha and see what she thinks, and then I'll decide if I need to adjust or anything. There's a hydrate command. Let me do that real quick. Oh, that's good. I'm thirsty. So, let me see. Yes, these are, I should give credit. These videos are all from the channel Old Squishy Gardener. Old Squishy Gardener's Court Watch does a ton of finding great court videos and putting them up on their channel, so I'd highly recommend them if you want to check out more court videos in your spare time. Can you be selfish and say tomorrow? Hey, maybe. I don't know. We'll see. I don't know how I'm a little nervous. I hope you guys like it. I'm afraid you're not gonna, but we'll see. Because a lot of you have already seen me cover this Hans Worm hat video. It's just I'm doing it in edited format, so I don't know if it'll be good, but check it out when it goes live, and I guess you can tell me and give me feedback on what you think might be, you know, good to change in the videos. Anyway, with that out of the way, if you're on YouTube, do me a favor and like the stream. Oh, we have a new new tip goal. Ban Pissmas. If we get this tip goal, we will never do Pissmas again. Pissmas will be dead. Pissmas is officially in the ground and buried, and I will never make you watch another video about people drinking their urine ever again. So if you want to get to that, use the tip link. You can also help out by gifting subscriptions. We're getting closer to our sub goal, so that's always good. And with all that out of the way, let's just jump in, shall we?
On the record in the city of Contempt versus Chelsea R. Lego, case number 26 CRB 15. In this case, Ms. Lego has been charged with a criminal offense. She was arrested as a result on January 21st, earlier today. The court is also going to take up 3 other cases where Ms. Lego has had warrants issued for her arrest as a result of failing to appear for a review hearing on January 15th, 2026 at 1 p.m. Those being 25 TRD 786, 25 PKT 26, 25 TRD 1019. Ms. Lego is appearing at this hearing.
So she's had multiple failures to appear already, and now she's claiming that she's going to take a plea deal, but she's going to waffle on it, and it's going to make the judge very upset. Janerdy with a 15-stream streak says, I actually got an email from my ex-fiancée acknowledging she was a bit of a crappy partner and that she'd wished she'd been the person I deserved. Admittedly, it would have been nice to get that shit 10 years ago when we were together, but still, I needed that more than I realized. Oh, that's good. Closure's always good.
By way of video from the Contempt City Jail. Ms. Lego, a criminal charge has been filed against you. Have you received a copy of the complaint?
Yes.
I'm going to read you your rights, so please pay attention to the rights I'm about to read.
Oh, thanks, Amalgamane.
You do have a right to be informed of and to understand the nature and the elements of the charge filed against you. You also have a right to know the potential penalties that could be imposed. You are charged with 1 count of obstructing official business. That is a second-degree misdemeanor. If convicted of this offense, you face a maximum 90 days in jail and a maximum fine of $750 plus court costs. You understand the maximum potential penalties you face if convicted of this offense?
I do.
Could you speak again?
I do.
Okay. Okay, you have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. And Ms. Lego, you have 3 plea options available to you
It does sound like Lego, but I'm assuming it's LIGO.
with respect to this charge. You can either plead guilty, not guilty, or no contest. If you plead guilty, that is a complete admission by you to the offense charged. If you plead guilty, the court will find you guilty, and then I will impose sentence. The second option is you can plead not guilty. If you plead not guilty, that is a denial by you to the offense charged. And as I said earlier, if you plead not guilty, I'll set your case for further proceedings after today, and I will set a bond. The third option is you can plead no contest. If you plead no contest, that is not an admission of your guilt, but it is an admission by you of the truth of the facts alleged in the complaint filed against you. If you enter a plea of no contest, this court will find you
We get
guilty, and I will impose sentence
I'm gonna
without
skip ahead a little bit because I think we all know what the pleas mean.
contest, cannot be used against. Explain to you.
No.
Okay, so with respect to this charge of obstructing official business, a second-degree misdemeanor, how do you plead?
Hey, Robert, it's set.
Guilty.
You understand, Ms. Lego, by pleading guilty to this charge that you are waiving your right to a trial, which includes your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses.
Why doesn't she plead no contest? Because that wasn't the offer. The offer was to plead guilty, I think. I think it's contingent on a guilty.
You'd be waiving your right to a jury
Because there's like a plea deal going on with this, I think.
trial. You'd be waiving your right to be proven guilty beyond a reasonable doubt.
3 to Apollo 13. Thanks for 3 months, says Noise.
All of those are trial rights you'd be waiving by pleading guilty
tea
to
time,
this
tea.
charge. Is that what you wish to do?
I mean, I kind of was in the wrong. Well,
Okay, but you've entered a guilty plea, and I want to make sure you understand by pleading guilty that you're waiving all of those trial rights I just explained to you.
yeah.
Okay, also by pleading guilty, you would be waiving your right to an attorney. You do have a right to have an attorney represent and advise you in this case. By pleading guilty, you would be waiving your right to an attorney.
Is that true? That's so weird. Wouldn't you still want an attorney to make sure that the plea deal is, like, fine and that you're doing a good thing and not making a bad decision? I feel like an attorney would be really good in that situation.
Is that what you wish to do?
I don't know.
Oh, boy.
I don't know.
Okay, I'm going to, I see some great hesitation in the defendant. I'm going to enter no plea on the defendant's behalf to this charge.
I mean, I was technically.
I don't want you to say anything that might incriminate yourself. I'm just, when I see hesitation by defendants like yourself, meaning they don't understand or they don't know what to do, I'm going to enter no plea. In this case, we'll have to proceed further. Okay, do you wish me to consider appointing an attorney to represent you?
Sure. Yes.
Okay, do you have any source of income?
Right now, no. I mean, I was working
When's the last time you worked?
a couple days ago. I've been cleaning houses. I just got a new house, so.
So you do it.
Wonder how she got a house just cleaning houses. I've done cleaning houses when I was younger. You don't make that much money doing it.
Kind of like self-employed?
Yeah.
Okay, how much on average do you make a week?
Well, I recently just started, so anywhere from $800 to $1,000.
A week?
Wow, she must be cleaning like ultra rich people houses. That's like insane. Or her turnover is just crazy. That's an insane amount of money to be making per week cleaning houses.
Yeah. give or take.
2,000?
How long?
I was taking care of horse stalls too, so
I'm
my
sorry?
neighbor.
Say that again?
My neighbor has horse stalls that I've been cleaning out.
Neighbor has horse stalls. That's a thing. Horses are expensive. M. Scheffler with a 10-stream streak says, "Hi, everyone. Hey, how you doing?" Oh, you're right. She must mean a new house as in a new client, not her house. That makes way more sense.
How long have you been doing this?
Quite a few weeks.
So you've been getting on average $800 to $1,000 per
That's the
week.
most
Oh, okay,
I've
1,000.
made so
That's a little more reasonable.
far.
Okay,
It's about $800.
What, on average, what do you make a week?
I don't know. Like I said, I just started, so let's say between $400 and $800.
Do you support anyone financially besides yourself?
My kids,
How many children?
I have 3.
Do they live with you?
They've been living with my mom, but I've helped her take care of them. I was in the process of getting them back.
Okay, I'm gonna make a finding that she does, based on what she just told me, she does qualify for court-appointed counsel, and I will appoint the public defender's office to represent her. Now I'm going to address the issue of bond. Where do you live, Ms. Lego?
Center Street, which is where my mom lives, and Harmon Road. Also Coney up.
So your mom lives on Center Street. Who lives in Harmon Road?
I do.
Who do you live there with?
Myself.
Do you rent the place or do you own it?
It was bought for me.
Wow, I wish someone would buy me a house.
So
Someone buy me a house.
if that's your home, why do you go
Because
between...
my children live with my mom, so I go over there. It's where you can find me. There's 2 places you can find me.
So help me understand, why did you fail to come to court again on
Because I never
January
received
15th?
it.
Excuse me?
I never received it. You guys have the wrong address. You guys have 480 Center Street. This is the second time I've missed court because you guys sent me the wrong people.
Ms. Lego, let me explain something to you. I have in the files a signed receipt. When you were last in court, you signed a receipt, and I'll give you the date. You signed it on December 10th, 2025, and it gave you written notice of the hearing on January 15th, 2026 at 1 p.m.
Ooh, yeah, you gotta put that in your calendar. You can't forget your court dates when they give them to you. That's so bad. That's such a basic mistake.
We didn't mail anything to anyone. We gave you notice in person on December 10th. So why weren't you here on January 15th?
I've had multiple court dates for stuff that happened years ago in Ashtabula. I've been overly worked, overly stressed. I've been dealing with things at home with my 11-year-old son. I didn't realize. I was thinking that it was more towards the end of the month. For some reason, I was thinking it was like the 30th. I had no idea it was the 16th, or I would have at least called and to reschedule something. I had no idea.
You did have an idea. We gave
I
you
did.
notice.
A whole month ago.
Yeah.
I've been dealing with a lot.
Carol Doubleman says, "I'd be perfectly happy with Hannah Takes a Vacation being the next goal. We already did that goal. I'm just waiting until the 1st of February to start. I took time off my, real-world job, too, so I can take the 1st, 2nd, and 3rd off. Little mini vacation, 3 days. It's not a ton, but hopefully it'll be enough."
A lot. My son is 11 and he's going through a lot of stuff. That's a whole different situation. I would have never missed.
The law director has submitted a bond recommendation asking the bond be set in the amount of $10,000 personal recognizance, alleging that on January 21st, 2026, in the bond recommendation. I think that's a wrong date. It's actually January 20th, 2026, that the defendant interfered with officers trying to conduct a traffic stop near the defendant's residence.
I simply asked them.
Be quiet. I'm not asking you to speak.
Oh, that was intense. That ratcheted up very quickly.
Are you receiving any treatment services for substance abuse or mental health?
No. I should probably see a counselor for mental ill. My son's going through a lot of shit.
Okay. So, have you ever received treatment for substance abuse or mental health?
I've received counseling, yeah.
Where
In the
at?
past.
Which agency?
Been a while. In Ashtabula, Signature Health.
Ms. Lego, let me make something really clear to you. Because we're not freaking messing around. Now you shut up and you listen.
Jesus Christ. Like, I get sometimes you gotta, I don't know if she's, like, out of line enough to, like, make this a reasonable reaction. Like, she spoke out of turn a few times, but I've seen defendants behave so much worse and have so much less pushback. Was this guy just having a bad day? Jesus Christ. Scary that, like, the fate of you after committing a crime can come down to the fact that a judge might just be having a bad day. Ooh, not great. Human beings are scary.
If you fail to come to court again, listen to me. If you fail to come to court again, like you have repeatedly done, if you fail to come to court again, and I issue a warrant, and you will be arrested on that warrant, you won't get out. Do you hear me?
I understand.
Because
Have I heard of the hungry judge effect? Oh god, is that something like right before lunch, judges tend to, like, give harsher sentences or something? Oh god.
I've had it up to here with you on traffic-related cases. This is the first case you've had a jailable offense. Your cases drag on and drag on and drag on because you fail to come to court. And I can't believe that I'm going to follow the prosecutor's recommendation here. However, there are conditions to your bond, so pay attention. $10,000 personal recognizance. You're ordered not to consume or possess alcohol or drugs. You are subject to random chemical testing by probation and law enforcement. You are to undergo an alcohol drug assessment at Signature Health, and you are ordered to comply with any recommended course of treatment. I am ordering that you undergo a urine drug screen today. You will not be released until you submit to a urine drug screen today. We will set this case for a pretrial conference in the near future when the prosecutor and your public defender are present. I will lift the warrants that were issued in all of the traffic cases, and I will set all of those cases for a review hearing on the same date and time as the pretrial conference in this case. Don't mess with me, Ms. Lego. Don't mess with me. You better be here when you're supposed to be here. Whatever calendar or calendars you have, the date and time that will be given to you for the next hearing before you're released, get it on your calendar. And then,
This tone is not appropriate at all for what's happened.
stop blaming
This is crazy.
everyone else for not...
Like, I get that it's serious to miss court dates. I'm not saying he doesn't need to say anything or that he doesn't need to make sure it's instilled in her. Like, you need to get this written down somewhere. I understand that, but, like, he's so vitriolic. Like, Jesus Christ.
being where you're supposed to be. Understood? Okay, this matter's concluded. Thank you. Thank you, officer.
That guy's an asshole. Jesus Christ. Oh, boy. Let me see what one I want to do next. Phew! Excuse me. I believe this is a two-parter, so let's check this one out. Apparently he laughs at the judge, which goes badly.
All right, first we'll take up Hernandez, GW 2024 CR 205, on the record, State of Kansas versus Luis Roberto Hernandez. Where,
Start your video, Luis.
Counsel, please announce your appearances.
Sorry, Your Honor.
May
No
it
problem.
court, the state appears by Jill Gillette, County
Thanks,
Attorney.
Amalgamane.
Richard Paul on behalf of Mr. Hernandez, who appears by Zoom at a separate location than counsel, and there he is, Your Honor.
How does he wish to?
I could probably find some Judge Simpson on Old Squishy Gardener's channel. I don't remember if I pulled any up. Let me look. Looks like we have at least one. Two.
Proceed, Mr.
Your Honor,
Paul.
we're set for sentencing today. I spoke with Mr. Hernandez, and he was scheduled for tomorrow to get his drug and alcohol evaluation, and it didn't. And then he called my office and realized that court wasn't when he thought it was today. So, Judge, I know we've continued this a couple of times. I know that there was a failure to appear beforehand. Mr. Hernandez is well aware of all that, but I'm asking for a continuance, Your Honor.
Mr. Hernandez, you entered pleas of no contest to DUI, possession of marijuana, on March 4th of 2025.
Don't smoke and drive, kids.
Almost a year ago, I told you to get the alcohol and drug evaluation. Are you hearing me, Mr. Hernandez? Start your audio and video.
Yes,
Okay.
yes, Your Honor.
All right. March 4th, alcohol and drug evaluation ordered. Sentencing was set for April 29th of 25. April 29th of 25, you didn't have your evaluation, so we set it over. July 1st of 2025, we ended up having a bond forfeiture hearing.
Oh my god, seriously? Oh, this guy's
Judgment
fucking up.
granted against defendant and bondsman to be included as costs in the case. August 20th of 25. The bondsman talked to me into giving me more time to try to get you here. Maybe the county attorney did that. October 14th of 2025. Sentencing
Isn't this the court where Cameron's disciples were going to be tried? I think so, at least some of them. I think Sydney for sure.
was reset to November 25th. You were ordered to contact your attorney and get your drug and alcohol evaluation. November 25th of 25, you were here with Mr. Paul. And we had to continue this again to today because you did not have your alcohol and drug evaluation. Here it is, January 13th, 2026, no drug and alcohol evaluation.
Why
Now you
is he
strike me.
Why is he pushing this off so long? Is he just constantly getting drunk and or high and he doesn't want to? Like, that's actually a serious problem. He can't even stop for like a certain period of time to go get tested. That's a serious problem that he needs help for.
He is a pretty pretty intelligent, responsible kind of guy. What in the world is keeping you from getting that alcohol and drug evaluation?
I keep getting drunk and high.
It was just it was just a simple misunderstanding on the court dates, and that's all it was.
Well, regardless of when you thought the court date was, you should have gone out the next day and made an appointment for your evaluation.
Yeah. Cause see, I thought that I thought that it was on the 15th is
Oh,
what
hey,
I
Cyrus.
had down.
You thought the evaluation was on the 15th?
No, I thought that the court was on the 15th.
Well, you're focusing on one failure to appear, which is a big deal. But how about all these sentences that you kept showing up without an evaluation like you're doing today?
Yeah.
That's the whole response. Yeah. I don't think that'll do it.
Well, I'm kind of thinking, where are you right now?
Oh, I'm at home.
Where's home? What town?
Wichita, Kansas.
Well, I'm kind of thinking maybe I just need to put you in jail and make the evaluator come to you, because the evaluator probably won't forget to get the evaluation done. What do you think?
I think I'd have the evaluation done quicker than it would be with the jail.
So far, you haven't.
I don't know. You've had since March 4th of 2025 and it's not done.
Yeah, well, see, that's all it was. It was just a day off. You know, like I said, I thought that the court was on the 15th.
Mr. Hernandez, you're
And that
not.
was it.
Is he just obsessed with getting it done like the day before court? Why is he not getting it done like regardless of when the court date is? He knows he needs to get this done. It's like he thinks he needs to do it the day before. Just go get it done. Anytime. Any day.
That was just an honest mistake.
You're not
And
even
I have no excuses for that, you know?
No, you don't. You have an appointment tomorrow to get the evaluation done? Did you say that, Mr. Paul?
No, I said he was going to have he was calling them tomorrow to get it. Judge, he's going through South Central, the Substance Abuse Center of Kansas.
Hydrate.
Judge, those people, they usually, what they do is when people call, if it's for an evaluation and it's a cash payment, they set those immediately. And then they get that immediately. Mr. Hernandez was going to have that done tomorrow, so he would have it in his mind ready for court on Wednesday.
Again, why is he waiting so long, though? Rick M with 40 bits says, if I'm ever in Zoom court and the judge asks me why I did it, I'll say Hannah Reloaded made me do it. Don't make me your patsy! I'm nobody's patsy.
He was definitely
Juggle, will do.
misunderstood.
If I set this over to Wednesday, will it be done? I've never seen one get done like that.
Yes. Yes.
Judge,
'Cause I called them.
They get them done. Luis, let me speak, okay?
Yes.
Judge, I've had them done in an hour before. I mean, they're right by my office. That's where I send all my clients, Judge.
What facility did you say that was?
Substance Abuse Center of Kansas, SAC.
You can get one done by Wednesday.
Well, I would think so.
He better do this. There's two parts to this, so he comes back on the next date. So if he doesn't have this done by the next date, I'm gonna lose it.
We can set this Friday on the PHC docket at the end.
Yeah, let's do that. Judge, he works. I'd rather do that than you order him to surrender.
We have 2 sinks coming on Friday at 2:30 and at 3.
How about 1 o'clock or
yeah,
1:30? How about what?
Brain Squid says, if anything, Hannah will blame us when she snaps after playing too much Femboy 911. Femboy 911 is the only thing keeping me sane. How dare you besmirch the name of Femboy 911?
1:30.
Don't make me play Femboy 911. I'll do it. We're gonna... it's done. We have to soothe our mental states. What if Astolfo was the South Tower? No, that's a reaction. I don't want a reaction. Oh my god, what happened to Femboy 911? Where is it? Oh my god, is Femboy 911 gone? It better not be. I'm gonna be so... Oh wait, no, there it was. There it is!
Huh? Why am I so big? In more ways than one. What's up with this?
What's the password? A second plane has hit the Femboy.
Why are so many men trying to enter me? They're going up my elevators and into my stairwells. I'm so big that everyone can see up my skirt. They're gonna see my boy parts. What? I'm not an office building. I'm just a normal boy. When my master finds out how many other guys have been inside me, he's not gonna want me anymore. What's that? I hear a sound approaching me from behind.
The internet was either the greatest mistake or greatest achievement human beings have ever made, and every day I'm in a constant state of flux about which one it is. Right now, I really couldn't tell you. I don't know.
What's even going on here? I see another tower next to me. Am I in New York? Huh? I see a plane approaching. He's going too fast. Oh no! It can't be. Someone used their noble phantasm on the North Tower. Oh, I hope that everybody inside there is okay. I couldn't protect them at all. Wow, what's this? I hear another plane approaching, this time from my behind. But I'm a tower. I can't move out of the way. I can't see it, but I think that plane is going to crash into me just like it crashed into the North Tower. No, it can't be. American Airlines Flight 175. That's bigger than anyone I've ever taken
I want to be clear, it's been 25 years. This is fine.
before.
It's been 25 years. You've cried enough.
I don't know if I
Laugh, damn it.
can do it. It's going too deep inside me. All of the men that are inside of me are going to get crushed. Oh no, everyone that was in me is currently trying to get out at once. It feels too good. It's so good that I can feel steam coming out of my top. I can feel my body. It's getting hotter. It feels like there's nanothermite going off inside of me. Oh, if only George Bush could see me now. It feels so good that I think I'm gonna collapse.
I don't know why I'm like this.
The
That's PhD
PhD docket.
All right, we'll put him on the PhD docket, and he will have that evaluation. And Mr. Hernandez, you will appear in the Greenwood County Courthouse for your sentencing.
Was that him laughing?
And if you cannot find a legal ride in a legal vehicle to get from Wichita to here, you call your bondsman with a mama bail bonds, and you tell her that they're gonna lose some money if you don't show up.
Well, no, I'll have a vehicle. The vehicle I'm in right now will get me there.
Well, you better have a valid license, and I'm sure Mr. Paul will say you're in.
No, as you can see, I'm in the passenger seat.
Well, I'm telling you.
Right, but if you're gonna drive there, you'd need a license.
Here's what we're doing. I'm going to continue the $5,000 bond that you posted November 14th of the year 2024 with a mom.
Green guy says, and Hannah won't read my fart jokes on stream. Fart jokes are lowbrow. Femboy jokes are aristocratic. I will not explain further.
Bail bonds. You must be here at the Greenwood County.
You wanna hang out, you're more
Is
than
this a
welcome.
Greenwood or a Butler County docket I'm on? You
Green-
will be here at the Greenwood County
I'll probably go back 10
Courthouse.
minutes, we can go out and have a smoke and chit chat.
You'll be here at, what time is that docket? Monday?
You got
Friday,
an update or something?
No,
Okay.
no, unless I decided to get
Missy, is this docket at 1:30?
Mhm.
Missy, 1:30?
1:30.
All right.
Yes,
You will
1:30.
be in Eureka, Kansas at the Greenwood County Courthouse Friday at 1:30. Now, that's just a few days from now. And you will have in your hands a drug and alcohol evaluation.
Uh-huh.
And if you do not have that, you're going to go to
This is
jail.
so ominous because there's a next video. Chat, let's do a poll real quick. Do you think he will actually get this done before his next court appearance? Let's do this poll. Answer this poll. You have 1 minute. Will he actually show up with the correct paperwork? Yes or no?
And you're going to sit there until we get that evaluation done.
All right. And what if I do have it? Which I'm
We'll
going
proceed
to.
with sentencing.
All right.
But Mr.
Like, do you want a reward? Do you want a reward if you bring it? Your reward is you're getting sentenced for your crime.
Hernandez, we've played around here way too long. This is just totally ridiculous.
Yes.
Wow, we are 97% no, 3% yes. No one has any faith in this poor man. I understand why. He hasn't earned it, but still.
It is. Yes, it is. Like you said, over a year, me on a bond. Yeah, it is.
Mr.
Ah.
Hernandez, let me do the speaking, please.
Okay.
I think you'd be better off if your attorney spoke for you, sir.
Yeah, I'll give him a call right now after I.
No,
make
you
sure.
just stop talking and let me talk on the record. All right. Mr. Paul, I think you've got this. Do the
I
best
do.
you can.
32-1 on the poll.
I do, Your Honor. Thank you very much.
All right, we'll be in recess.
Thank you for your indulgence in not taking him into custody today. We appreciate that.
You're welcome. All right, Mr. Hernandez, you better leave the screen before you get into trouble.
And then let's take up Mr. Schenkel. He's at the Greenwood County Courthouse since it's.
All right, let's see part 2. Did he get it done?
Do we have an alcohol and drug evaluation?
No, we do not.
I really thought he would. I'm, you know, maybe I'm just ignorant. Maybe I'm too hopeful. I really thought he was gonna. I thought he would, because this was clearly a last chance. This was it. You had to do this, man. You said you were gonna do it on camera in front of the judge, and still, you didn't do it. What were you doing? Oh my God.
Oh, you did not want to tell me that today.
I understand, Judge.
All right.
Let's go ahead and call the case, and I'll give you the story. Okay.
Oh,
I'm excited for the story.
okay. We are on the record in GW 2024 CR 205, State of Kansas versus Luis Roberto Hernandez, County Attorney Jill Gillette for the state, Attorney Richard Paul for the defendant, who also appears in person.
Grizzly.
Appearing in person on order of the court. Now, the second thing is, he was ordered to be here in person, and he was ordered to be here with his evaluation in hand, having had this thing continued repeatedly to get the evaluation. Court recalling that he was to get it at a facility next to your office, Mr. Paul, and you said that they were pretty quick at turning them around. So here you go, Mr. Paul.
Well, thank you, Judge. Mr. Hernandez did try to do all of that. Unfortunately, he doesn't have an ID, so they wouldn't let him do an eval.
Oh my God. This is why it would have been good to go there much earlier, so you could have realized that there was an issue and corrected it by getting some kind of ID. Even if you can't have a driver's license because of your current charge or whatever, you can get a state ID that isn't a driver's license. He could have had the time. He had, like, what, 8-10 months? He absolutely could have gotten an ID. Unstable Deadbeat with 40 bits says, I bet it wasn't his fault. I bet Sack dropped the ball.
All right. Mr. Hernandez has repeatedly denied my order for whatever his excuses to get that evaluation done, and that goes clear back at least till October, I think even long before that. In any event, officer, I'm ordering that he be taken into custody and that he sit in the county jail until he gets that evaluation done. And I will order whoever you can get in there to get in there and do it. Deputy, can you hear me at the Greenwood County Courthouse?
Yes, ma'am.
Take him into custody with the order that he gets his drug and alcohol evaluation done in the county jail. And Missy, when can we do his sentencing?
I'm not sure how far you want to go out because I don't know how long it'll take to get that done.
I don't know either. Miss Gillette, any guesses? Estimates?
I was just texting the jail and the jail liaison for mental health and treatment stuff. So I don't know till they answer me. But I would say let's put him on for a status on like a 3:30 docket. When's our next one, Missy? We have one January 20th, which is this coming Tuesday.
Oh, that was yesterday.
And
That's probably too soon, I would think.
well, then we'll know at least if it's scheduled.
There you go. You said status. So for status 3:30 this coming Tuesday, which is what?
The 20th, January 20th.
All right. Mr. Hernandez, you have been a very difficult defendant trying to get this done. Maybe now it'll happen. Now, counsel, I want to make sure that someone contacts the appropriate agency. Will it be Crosswinds, probably Miss Gillette, that will go in to visit him?
I'm gonna check with Crosswinds. I don't know. Sometimes we have SAC, sometimes we. So I was gonna
Well,
text.
SAC is the one next to Mr. Paw's office.
Mhm.
So, but whatever you can do, and technically I'll have to get Judge Ricky's prior approval for if we have to make the payment directly. I'd like to put it in the journal entry that the defendant is responsible for that directly, but whatever we need to do to get that evaluation. So this defendant, actually it's been since March 4th that he was ordered to get that evaluation. March 4th of 2025, and we still haven't gotten that evaluation. And we have 1, 2, 3, 4, 5, 6. This is about the 7th hearing. All right.
7 hearings.
So
How did he avoid jail this long?
Mr. Gillette, I'm going to put that in your hands to make sure that
Like, I feel like at hearing 3, he should have probably gone to jail.
someone gets called and that you and Mr. Paul coordinate to get that done. And we'll look at it again. I like your idea. The more I think about it, Ms. Gillette, that we do a status on January. You said January 20th at 1:30, right?
Yeah,
3:30.
at 3.
3:30, yes.
On 3.
3:30. That's just 4 days from now. Okay. All right. Go with the officers, Mr. Hernandez. Don't get into any more trouble. Is that enough? Officer, do you have him?
Yeah, they're.
And I don't want him to be busy with something else and let him walk out the door.
Wouldn't that be terrible if he did
That was
just walk
Deputy
away?
Lazar that was in charge there.
Leonard.
Oh, that was Leonard. All right.
He has him now.
All right. He's in your hands, Deputy. Okay.
Yes, ma'am. I'll take care
Thank
of it.
you. Appreciate it, sir. Now then, who do you want to take up next, Mr. Paul?
No one.
No one? That's your last one?
It is. And thanks for asking me. And when you asked McClendon if it was okay if they went first, you didn't even ask me.
I sure am.
I know where I rate.
Sheesh. Well, at least he'll get the thing now. That's good. Let's see what else we have. Oh boy, this is about a teacher, I think, who showed up to work drunk, I think?
On the record, in the matter of
I
the
think this is her sentencing hearing? I'm not sure, actually.
state of Michigan,
Oh, she violated court orders, so this is some sort of, like, hearing about that. Okay.
was Brittany Poole, 251344.
Morning, Your Honor. John Goldblatt, P 30758. Ms. Poole, please put your name.
All right, good morning. And today is the date scheduled for sentencing on your client's plea to operating while intoxicated. The high BAC and OWI with an occupant less than 16 were both dismissed by way of resolution between
Oh no, with a kid in the car, too.
counsel
Apparently DUI, not at school. It just said she was a teacher, so I assumed it had to do with her job.
at the pretrial. And counsel, do you have an opportunity to review the report and recommendation with your client?
Yes, we did, Your Honor. Your Honor, there is also a bond violation.
There is also a bond violation.
As to the bond violation, Your Honor, the bond violation is that she failed to appear on,
So many
She tested
failed to
positive for
appears.
alcohol
Yes.
on December 15th, December 22nd. Hold on.
Orion with a $2 super chat says, I stumbled on a pastor Sopsit today. Want a link? Yes, if you can post it on the Discord, because you can't post links on YouTube chat.
Excuse me, I didn't mean to cut the cord off.
By the way, everyone should join the Discord if you haven't already. It's a lot of fun. Lots of cool people there. Here's the link.
She tested positive for alcohol and cocaine. And then
Oh, and Coke. Oh, no.
on
Mixing uppers and downers. That's not great.
December 3rd.
December 3rd, she failed to appear on the 15th, the 22nd, 2nd, and the 5th of January. As to the bond violation, you would plead guilty to that violation. Is that correct?
Yes.
I can't hear you, ma'am.
Yes.
Please raise your right hand. You solemnly swear or affirm testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth.
Yes.
And you heard the allegations that were placed on the record, correct?
Yeah.
As to those bond violations, how do you plead?
Guilty.
You've gone over your advisory rights regarding bond violation, correct?
Yes.
And you understand all of those rights.
Yeah.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yeah.
And you understand the possible penalty as a result of your plea. That this court could revoke your bond, this court could amend your bond, give you additional conditions, incarcerate you for a number of days or otherwise. Do you understand that's the array of of possible consequences?
I mean,
And knowing all of that, do you want to continue with your plea? Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
I always find that to be an interesting question, because by the very nature of a plea deal, it's coercive, right? How are you supposed to say no to that? The entire thing is incredibly coercive. Either you can try to go to court and take your chances, or just plead guilty and we'll take some of these charges off. Like, it's inherently coercive. I'm not saying it's like something we need to get rid of. I'm just saying it's very weird to me that we pretend it's not when it clearly is.
And
Thank you, Orion Cooper.
counsel, if you can please vote to your client.
Thank you. Ms. Poole, you're on a bond to this court. Is that correct?
yes.
And
And you need to speak up so we can record you, okay, please?
Yes.
And on December 3rd of 2025, did you, consume any alcohol?
Yes.
And that was in violation of that bond. Is that correct?
Yes.
And on that date, or just prior to that date, did you consume or use cocaine?
No.
Did you use marijuana?
Yes.
And marijuana was
Alcohol, marijuana, and cocaine? Jesus Christ, lady. I'm starting to think that you have some deeper issues. Oh my god. Just sitting there. Smoke, snort, drink, smoke, snort, drink. Oh god, that's terrible.
in violation of
I
that.
hope she gets help through this situation somehow, like mandatory substance abuse treatment or something, because like that's bad.
As well, is that correct?
Correct.
And did you obtain that marijuana from a friend or something? Is that correct?
Correct.
So you don't know what was in that marijuana, do you?
Yeah.
And you were supposed to test on the 15th, the 22nd, the 2nd, and the 5th. Is that correct?
Yeah.
And did you appear?
I did not.
Defense is satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the bond violations. And counsel,
Your Honor.
there are 5 violations.
5?
4 missed tests and
Right.
1
Oh, I'm-
positive.
Okay.
I'm taking, even though your client tested positive for alcohol and cocaine, I'm taking that as 1 violation because it's on 1 day.
Thank you, Your
Well, that's very nice of her.
Honor. Your Honor, she's indicated to me that the relapse as to the alcohol, she understands that she clearly is not supposed to be doing that in violation of the bond, particularly with respect to the charges. She denies the cocaine. However, she did indicate to me that she did smoke marijuana. That did not appear. So
What? She's saying she didn't do cocaine, but she smoked marijuana, but is she trying to imply that the marijuana was laced with cocaine?
Which calls into question
Do people do that? That's probably a thing some people do. Wait, can you smoke cocaine? You can. You can smoke cocaine. It's just not efficient, right?
whether or not your
I don't know drug things. I'm not a cool kid. I'm sorry.
client really smoked marijuana or just used cocaine.
or used marijuana, which was tainted. And that's why I raised that, because she didn't go to a dispensary to get it. But this is what I'm indicating. As to the,
Actually, counsel did show marijuana in her system.
oh, I didn't see that one. Oh, it does, you're right.
So really, it should say she has a positive for alcohol, cocaine, and marijuana.
And she's admitted to the rental as well as the alcohol. Although. As to the mistakes, she was going through some financial problems. She lost her car, is that correct?
No, the training issues and
I'm sorry?
transmission issues and getting rides.
She understands that it's a violation and she had to take care of this, you know. We're asking the court to take all of that into consideration.
Did you communicate any of that with the court, ma'am?
I had called and I did leave a voicemail on,
I cannot understand her at all.
With who?
Ms. Shine.
Did you hear anything back?
No,
Did you email?
no,
Did you get a ride up here?
no, it was hard to get rides in general.
If you were to test right now, ma'am, what's in your system?
Nothing.
Ma'am, you work with children. You're an assistant teacher. And this is who is assistant teaching these kids? The person in front of me today? And not only that, we're going to jump to the sentencing for a moment. You had your 4-year-old nephew.
4 years old in the car while she was high? Oh, that's ridiculous. Her sibling, whoever's kid that is, should never let her alone around that kid again. That's ridiculous. Do you know how much danger you put that kid in? You could have killed them.
In the vehicle with you. It's not even your child that you put in jeopardy. Somebody else's child. Which, if I recall correctly in reviewing the report, the parent of that child has passed, and then your dad has guardianship or custody of the child, correct?
Her sister's dead.
Dead parent too, and you're endangering this child drunk and high.
Your sister's dead. Okay.
People make bad decisions. I understand addiction, because you guys know, I used to be a severe alcoholic. I've been sober many years now from alcohol. I still partake of weed. But oh my god, addiction is such a terrifying thing. It makes you do stupid, stupid shit. You have no idea.
And so
I hope none of you ever have to deal with it. I really do. I wouldn't wish it on my worst enemy.
you had taken the child for the day or what have you, correct?
Yeah.
And this is what you did. You took the child with you to a friend's house. No? It says that you stated you were at a friend's house in Lincoln Park and headed to the gas station. Quite a few mixed drinks.
I was at my friend's house prior to getting the nephew.
Oh, so you picked your nephew up while you were intoxicated.
I've been drinking for it was most the summertime before we went back to work, and we were drinking for a few days, up and down. And then the next day, I got my nephew taken to the dentist.
Pam, you are 0.229.
0.22? That's almost triple. Wait, no. A lot of places it's 0.06 now. So that's almost 4 times the legal limit in a lot of states. How was she conscious, much less driving a vehicle?
So you were drinking
3 times the limit if you're in a state where it's 0.08, 4 times if you're in a state where it's 0.06.
for a few days before school started. Were you on a 72-hour alcohol binge?
Yeah, I noticed. That was weird how she said she'd been drinking for days, like it's a normal thing. Like, that's not a thing normal people do, just constantly be drunk for days at a time. That's already a sign that you have severe alcohol issues.
It wasn't nonstop, but we did drink a lot for those days.
Okay, and you didn't feel any differently when you went to pick up your nephew?
Not at home.
Well, that's a problem.
Yeah, that's bullshit. I
At
don't
a
even think
point
that's true.
229, you didn't feel any differently than you would have if you were a .00.
No,
Okay. And so if you were to test right now, ma'am, what's in your system? Not even marijuana?
Oh, the silence. Oh no, is she drunk right now?
And you do not feel that you have a problem with alcohol? Okay.
I think she needs to reevaluate that.
All right, counsel. Anything else you'd like this court to know?
With respect to the bond, Your Honor, or the sentencing as well?
Either one.
Well, we have reviewed the pre-sentence report. There were no additions, deletions, or corrections to be made. Ms. Poole has pled guilty to the violation of the bond violation. We're asking the recommendation be adopted.
Okay, with regards to the bond violation, this court's going to order 10 days jail.
Court consider suspending that?
No, I'm not considering suspending that. There's 5 violations. That's 2 days each violation. This court's also going to indicate after hearing from counsel reviewing the report, the recommendation that the court does find that there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Poole and the legislative guidelines. This court's going to order 18 months of probation. You're eligible for early discharge, and I'll go over that shortly. You already have be on an alcohol tether for 45 days after you are released from jail. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually.
She's actually, I'm actually worried about her just quitting cold turkey off alcohol. Like, if she's genuinely doesn't feel that drunk at .22, even if she does feel drunk at .22, but she's still conscious, she's like severely addicted to alcohol, and if you quit cold turkey, that can kill you. So I feel like she needs to be in some sort of facility that can help her step down off it without being a danger to herself, but I don't know. Gothgeek Gaming with 40 bits says, my physical health team won't give me anything for pain despite my arthritis, neuropathy, and complete spine stricturing, so I have the complete opposite issue of substance abuse, if there's a term for that. I am so sorry. That's not cool.
You are to notify your probation officer immediately of any change in address or employment status. Do not use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for this condition is so that you can further, the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so you can have assistance in providing coping mechanisms so you can maintain sobriety, prevent relapse. Hopefully preventing this matter from happening again. You are to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is so you can further increase your understanding of the dangers of driving while under the influence and the consequences of such behavior. The court's going to also order you to participate in fan meetings once per month. The rehabilitative goal for that condition is so you can have additional support to maintain sobriety as well as recovery resources. The court's going to order you to participate or to for the workforce, 7 days on the court workforce. The rehabilitative goal for that condition is to help you further develop life skills and give back to the community. The court's also going to order you not to have any unsupervised contact with your nephew.
That's probably a good
Any
idea.
questions
for the time
regarding
being.
those conditions? The court's going to order a $300 fine, $100 screening assessment fee, $900 supervision oversight fee, that's $50 a month at 18 months. And since you're eligible for early discharge, up to half of that will not be due. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, and workforce is $280. That's 7 days at $40 a day. And so that's a total of $2,005. You did post a bond, we'll apply your bond, and then you can set up a payment plan with probation upon your release. So you are to report to probation
Your Honor, would the court consider,
upon release.
would the court consider with respect to the bond violation, rather than her appearing, being taken for sentencing, today, that she here, should she go to work for the rest of the week and then show up on Monday?
No, you're going today.
I'm just gonna do my job and then I'm not gonna get one, I don't know how to pay all that.
Ma'am,
Oh, that's not a good thing to say. She said she's not going to pay all that. That's not your decision. It's a court order. It's not voluntary. If you don't pay it, they will put you in jail.
your actions have put a number of people at risk. Your 4-year-old nephew, yourself, the community. You've indicated that you did not feel any different at a .229. You violated this court's order 5 different times. 5 different times. So you're going out this door today.
Your Honor,
Thank you. Have a good day. Okay, off the record. Good morning, Wayne County Jail. Can, Mr. Mullen, can you grab the prosecutor and we can, or no, I'm sorry.
I really hope she gets some help. I know that she's going to have to in the court and stuff, but I don't know. I just hope she's able to get something out of treatment because she is in deep. Very deep. I know someone asked for a Judge Simpson video, so here's one.
Court calls the case people versus.
Apparently this is about defendant's daughter causing some sort of commotion during the mom's hearing, and then she tries to run out of the courtroom.
Latricia Mopkin.
Hannah Mackey on behalf of Mrs. Mopkin, who's approaching.
No, look this way, ma'am. Come on up. Your name?
Latricia Mopkin.
Thank you.
Your Honor, requesting to set this matter for preliminary examination. May I just bond, Your Honor?
You may.
Ms. Latricia, she works at U of M as a housekeeper. Currently, she's on non-paid leave. However, that's temporary and she could permanently lose her job there. She has 4 kids and one of them, Ms. Latricia is the sole provider for her kids. Her family is here today in court as well, and she has a place to stay with them upon release. So we're asking her, Ms. Latricia, to be released, and she is okay with complying with GPS tether or any other conditions the court finds necessary.
Responsible.
Your Honor, at this point, I'm gonna object. This is an extremely serious case in which the victim was attacked with a hammer in which she was hit in the head several times with that hammer.
Oh my god, she battered someone with a deadly weapon?
There was a struggle then for that hammer, and then during that struggle, he was then stabbed in his stomach. So given the severity of
You hit someone with a hammer and then stabbed them? Yeah, I don't think you're gonna get out on bond.
this case and the injuries that she sustained, I'm gonna object at this time to any modification of bond.
And Your Honor, we are presenting this
What's up with the 4th panel? That's just what the court is recording. They have people waiting in basically the line to be next up after this case.
case as a self-defense, and Ms. Latricia would not be staying at that address upon release. She would be staying with her daughters, looking after her.
I mean, typically the self-defense isn't, I mean, are you indicating that the alleged victim possessed some weapon at some point?
I believe there was some form of altercation.
Well, an altercation is one thing. are you saying that a weapon was possessed? Because
No.
that might factor into the court's decision, but if that's not what's being said, then I'm not sure that true self-defense is going to apply in any event, although I'm not trying to make that analysis.
There was no actual weapon.
Do this. There's the allegation that there are two weapons that would be used by this defendant.
He did have a knife, Your Honor.
Okay, then you can certainly address that even, while I'll factor that in, I still don't think bond would be appropriate or a reduction in bond would be appropriate in this case. I'm going to deny your request. Certainly you may raise that after the preliminary examination on the 20th before Judge Freshow.
Thank you, Your Honor.
Thank you. Guys want to walk around? Young lady?
Ooh.
No, come here. Come here. Oh, boy. Get her, Mr. Allen. Who is that?
Yeah, it's not good when you make Simpson mad, because he's usually pretty level-headed. It takes a bit for him to get upset. Not a good idea to, like, freak out in court. Ugh.
Who was that? What?
Is it a full moon?
No, people are usually better. They're not back yet. There's a problem. You got a problem probably in the hallway, guys. How
long does it take to get her back? Jesus.
Right, I'm gonna step off. If she brings him in, just throw her in the box over here or cuff her, put her wherever.
Oh, here she comes.
Yeah.
The PD can handle this, I think. She can go back into custody. I'm gonna take a brief recess and then I'll bring her back out. We'll deal with it.
All right.
Guess in reference to this case, we'll call it in regard to the Mopkin matter. The defendant does not need to be present and is not present. I think Joy was.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of the respondent, defendant. I don't.
Yeah, yes, she would be a respondent. Your name, ma'am?
Sequoia Jones.
Ma'am, you know why I held you?
Yes,
Tell me what your thought is on why I did.
because I disrupted your courtroom.
Yeah, you disrupted the courtroom, and then when I asked you to come back, try to figure out what was going on with you, you just kept continuing to walk. Why'd you do that?
My mind was like blank. That's my first time seeing my mom since, and it was just like a lot. It was a little too much. It was my first time seeing my mom since this incident happened. And I was trying to ask the lawyer something. I was so focused on her answering my question. I couldn't even really like hear anything else. I was too upset. But I'm not using that as an excuse. I take accountability. I was wrong for that. But
Your mom's coming back in a week or two, right?
That's correct, Your Honor.
Huh?
That's correct, Your Honor.
So is it that you can't, in seeing all of that, can't keep yourself composed in the courtroom?
no, I thought it was an understanding before my mom got up here about mentioning her injuries, and nothing was mentioned about that.
Okay.
And that's what I was asking
Can I
her.
just say this?
Oh, okay.
You need to let the attorneys do their job. Okay?
Mhm.
You have an issue to the extent that they'll even talk to you. If you have an issue with that, then you deal with that outside of this courtroom. So should I banish you from coming into this courtroom again?
No,
You think you can conduct yourself?
yeah, yes,
Young lady, I'm gonna give you another chance. if you come back in here and act the way you did, I'm gonna guarantee you this, you'll be locked up like you are now, but I'm not letting you out.
Simpson is so much. Remember the yelly judge from earlier? Simpson is so much better. He's being serious about this. It is something that needed to be addressed because you can't have outbursts in court like that. But he's not just screaming at this girl. He's not just yelling and intimidating her. He's with a serious tone, imparting the seriousness of this and why you can't do it, and warning her, next time don't do it, or you will have consequences. Very reasonable. He's a great judge. I really like Judge Simpson.
Are we clear?
Yeah, I have no problem with that. I'm not a disrespectful person.
You're not what?
I said I have no problem with that. I'm not a disrespectful person. I wasn't.
Oh, you were today.
I was today, but I'm not.
Not only
every
to
day.
whoever you were talking to, but also to me, and I hadn't done anything to you. Right?
Mhm.
So just check yourself next time before you come in here. All right, we can release it. Let her go.
Thank you.
Thank you. Court is staying in recess, and I guess we'll come back and do our 2 o'clock block and on.
Let's do another Judge Simpson. I have another one. I love him. Oh no, this is a person who shows up drunk to court. People gotta stop doing this. Don't get drunk before you go to court, people.
Court calls case of People versus Joseph Hafner Cantor.
Alex Warren, Green Hafner Cantor.
Here, Your Honor.
Can you state your name?
Joseph Hafner Cantor. All right, what are we doing?
Your Honor, we're asking for a preliminary examination at this time.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before me.
Where?
Bond continued. Thank you.
I think last time we were here was December the 4th.
Pardon?
Last time we were here was December the 4th. I have a violation dated December the 9th. Bond violation, of course.
And we are in receipt of that, Your Honor. I did review it with my client.
You have a bond violation? I do. Behind that, I need these in the front.
So Your Honor, it does seem to indicate,
We were here last on what day?
I thought December the 4th.
Yes, I have December 4th. And I got,
So it does appear that these tests were in the interim period between the last time we were here and this
Mr.
meeting,
Allen.
with positive alcohol blows on the silver link.
We've got a positive on December 8th. And then missed test really through the 9th, early into the morning. So the 8th was at 11:37 p.m. 0.07. And then 04, probably the same alcohol, maybe a little bit more, by 8 a.m. that morning. So some 8 hours later, he's still blowing numbers. Except that then a little bit later, it popped up and then went down. So it looked like he was continuing to drink. Then the worst thing happened. They spoke with him. And he said he didn't have any alcohol.
And Your Honor, I believe Mr. Hafner Cantor is changing his position on that now.
Really?
He did appear on the same day that this violation report was submitted. He appeared before Judge Frushauer to be
I
arraigned
believe the top left, the guy standing behind the lawyer, is the drunk defendant.
on a misdemeanor OWI. The misdemeanor OWI date of the alleged offense predates this case. I think it was just authorized later due to lab results. But nevertheless, he appeared for arraignment knowing that this violation was there, and it was addressed at that time by Judge Freshour, who had him taken into custody with a $5,000 10% bond. I think the condition of that bond
On this case?
he was taken into custody at the time of his arraignment.
You're saying two different things to me. Her taking him into custody at the time of the arraignment is one thing. If she's taking him into custody on this case, that's a different thing and not something that I see in this file.
And you're correct. What happened was, after the court considered this bond violation and received the report from his tether agent, bond was set in the amount of $5,000, 10%, with the condition that he be fitted with a Scram tether before that bond shifts to a personal bond. So he was fitted with a Scram tether. He remains on that Scram tether since December 9th, and I don't believe he's had any violations. Mr. Hafner-Cantor is employed and has stable housing with his employer in Saline. Your Honor, I would ask the court to consider continuing his bond, because I think
Wonder how they realize he's drunk.
being on a Scram tether is kind of the constant reminder he needs not to drink. I will note the present offense. I don't believe there are any alcohol related allegations, but of course he does have a misdemeanor OWI, and he admits he has a drinking problem.
Yeah, but this response from the people.
The people are glad that he has now a Scram order on the OWI case that's pending before Judge Freshour. However, it's still a violation in this case to have been drinking. I'm not sure. I know the court generally will issue warrants pretty quickly when these things sort of come through. I'm not quite sure what happened here, but no matter what, it does.
Was there a warrant issued on this one?
It does appear to the people that alcohol is a significant problem for the defendant. It appears that the SoberLink is not working. So I would ask that the court at the minimum order the Scram in this case as well.
Did he take the ETG?
Doesn't look like it from this report.
He did not give me one.
So there was a warrant issued on this one, okay.
Okay.
Is it still out?
For Mr. Hafner?
Yeah.
Okay.
No, I do not see that warrant.
Oh, you do not see that one.
I do not see, no. So he was, the report says, I advised him to report to community corrections for an ETG urine test by end of the day. This is on 12/9. He said he had court and only had transportation there, doesn't have any money to take the urine test. I advised him a violation be sent, and I was affording him the opportunity to take ETG test to provide results with my report if in fact he was not drinking. And I just confirmed with Mr. Cook. Mr. Cook informs me that the defendant had a positive BAC coming into court. I'm not sure if that's related to this violation report or if it was actually going to court, but it does all appear to be on the same date, that December the 9th sort of timeframe.
So when did he appear before Judge Freshour?
It looks like December the 9th,
That's correct.
What time?
9-ish in the morning.
So
I'm gonna be so disappointed with this title if they don't discover he's drunk here, because the title makes it seem like he's drunk right now.
Man,
there's no indication so
may
far.
not have been aware then.
She was aware, she remanded him, and
But was she aware that he was intoxicated?
Mr. Cook's note indicates, and his communication to me indicates that he had a positive BAC coming into court. I'm assuming that means he was blowing numbers at court. And I know that community corrections was there.
Okay, I'm pretty much done. I mean, you drink coming into court, you drink in violation of my bond. I saw you 4 days beforehand.
Okay, so it was a previous hearing that he got drunk before court?
And
lame?
no, we don't do that. Say whatever you want.
Your Honor, I think what Mr. Hafner-Cantor wants the court to consider is that he, since this string of events leading up to the court date on December 9th, I think he has pivoted and changed his position from denying
So let
his
me get this
problem.
right. You're telling me that all of a sudden everything has changed. On December 8th, he's drinking. He's drinking well into the morning on December 8th. He has to appear in court, can't stop drinking, and then ends up at court that day. He talks to community corrections, I think, on that same day and just is absolutely lying to them. And somehow between now and that date, he has made a certain epiphany has occurred and he's made some miraculous transformation. Is that what you're telling me?
Your Honor, I understand the court's concern. Mr. Hafner-Cantor, when were you released from the Washtenaw County jail? Was it the following day or this?
I was there for a week. I think I was released on the 19th or the 18th.
So, Your Honor, he's strung together 10 days on a Scram tether with no issues whatsoever. And I think that's what he wants the court to consider in reassessing bond here.
Okay, so he is sober today.
I would ask the court to continue his bond based on the fact that he's come into compliance since being placed on the Scram tether.
He's in violation on my case, goes to another court drunk.
And Your Honor, I would like to correct my record I made to make sure that it's accurate. Mr. Cook has let me know that he doesn't know if the defendant was individually touched at the court, but because he had the 0.04 30 minutes before the judge saw him, Mr. Cook's note was that he was drinking. So I apologize if that was confusing at all. I just want to make
So he wasn't breathalyzed at court.
now that Mr. Cook is aware.
Where?
But
It's because it was 30 minutes before, there was an assumption that, which is a good assumption.
it's pretty fair, yeah.
Anything else?
Yeah, there are ankle monitors that also monitor your blood alcohol level, and they like ping the service if you get drunk or anything.
Your Honor, I know Mr. Hafner-Cantor's been in constant contact with his community corrections agent, and I know that his 3-year-old daughter, who he takes care of, is his biggest concern. I think he was dealing with some stress regarding a custody situation with respect to his daughter, and
He's violated my bond. And then absolute disrespect showed up at another court, still under the influence of his drinking event that violates his bond in this case. And he's appearing at that time on an OWI. And he's not in any treatment. Anything else?
Nothing from the view.
nothing further, Your Honor.
Bond revoked, defendant's remanded.
Your Honor, and
The 13th is.
and with respect to that date, he does appear in district court on that same date. I'm not sure if the court wants to move it or if the jail would be able to accommodate that
District court where?
for the OWI case.
Well, he wouldn't exam until much later.
Okay.
Which judge is the exam?
Me.
Thank you.
Thank you, Your Honor.
Yeah, don't get drunk before court. Not a good idea. Let's try this one.
And this is file 24-01353, People versus Devion Bashan Talley.
Good afternoon, Teresa Johnson on behalf of and with Mr. Talley. We're here today for a bench warrant arraignment. We'd ask that the court set aside the bench warrant. He is here and has availed himself of today's court date, and I would like to ask the court to consider a bond at the appropriate time as well.
You would hear consenting to Zoom.
We are.
Recall the bench warrant. One of the somewhat unusual factors in this matter is the court required that he appear for arraignment. Mr. Talley is in the building, and the judge noted when he made that requirement is the defendant has failed to appear 6 different times. So we'll reset the hearing. And when the judge signed the warrant for the arrest of this man, he set the bond.
We're a little halfway through the stream, so I got to do my little calls to action. If you're on YouTube, do me a favor, hit the like button. It helps with discoverability a lot. If you want to help support the stream, you can always use bits, subs, or tips.
I believe at $2,500, but let me
Speaking of which, Quasispec, thanks for 1,000 bits. Thank you so much.
check that to be sure. Yeah, he set the bond at $2,500 cash surety or 10%. So ask the bond, please.
I am hoping that the court will reconsider the bond. I know that, and I spoke with Mr. Talley about the fact that he's already forfeited a bond.
I don't know, man. With that many failures to appear, I doubt you're going to get the bond dropped. M. Scheffler with 100 bits says, Hannah, why is Jason X so bad? Like, how did that POS movie get made? I love Friday the 13th and Jason, but damn, that movie sucked. Are you intentionally baiting me? I like Jason X. It's like a so bad it's good movie, but it's so entertainingly, like, it's, how could you dislike Jason X? He kills people on a holodeck. He turns into Uber Jason. How dare you? Nemesaur, thank you for gifting 20 tier 1 subs and kicking off a hype train. 8% to level 6 on the hype train. If you want to help, you can use bits or subs.
The court did set a new bond that he's going to be required to pay potentially if he does not get a personal bond. Unfortunately, he is not in a position to post any additional monies right now. He did indicate that he now has a valid license, which is part of one of the issues. He was not able to get to court to get things squared away because he was still trying to work on getting a valid license, which he now does have. He did avail himself of the court. He does want to get this matter resolved. So I'm hoping that the court will take that into consideration in determining if you believe that reverting his bond into a personal bond would be appropriate in this instance.
Got his license back because he was an operation driver, I believe.
I believe so.
Mr. Talley, one thing you have to understand is that when there's a court date set, you have to be there.
I just had the time.
You're in court now. Take off your hat, please.
Yeah, I came.
M. Scheffler with 100 bits says, I never disagree with you, but you're so wrong. I like bad movies. I love The Greasy Strangler. Jason X is so bad, it's bad. Hard disagree. It's an entertaining movie. I wish I could watch it with you all. Unfortunately, we cannot, due to international copyright law. However, I will die on this hill. Jason X is a cheesy masterpiece. It is so silly and stupid. The sets look like they're from Xenon of the 21st century. I love it. I will always love that movie.
It was like an hour late because I set my alarm for the room.
Well, then you weren't here.
Yeah,
Six different times?
I don't know about 6 different times.
I do. That's what the judge reported.
I do.
They reported, but I don't know about that. No, I got a lot going on. I got a newborn. I just got a lot going on. I know it's not. You don't care.
Mr. Talley, do you know anybody that doesn't have a lot going on?
I know a lot of people that have less going on. Yes.
That's a bad answer. Oh no, and you're not making eye contact. You're like fucking around in the chair. Look, I'm neurodivergent, so I understand that, like, especially when you're nervous, it gets hard to, like, focus and, like, look someone in the eye a lot of the time. But this is not a good look for court. It's not fair that things work this way, but the way you present yourself matters, so probably pay attention, man. Oh. M. Scheffler with 50 bits says, boo, boo, you're bad and should feel bad. I don't feel bad, and I'll choose, instead of assuming those boos are derisive, I'm just gonna pretend you're a ghost. So take that. 14% to level 6 on the hype train with a minute left.
You need to come to court as directed. Do you still live on Martin Luther King Drive?
Yeah.
Is that yes?
Yes.
If bonds were to be set based on the apparent spirit of cooperation, you wouldn't be leaving here today.
How
Sweet Lily Love says, I was saying boo earns.
am I not cooperating? I came here. I didn't have to come here.
I'm talking about your attitude.
Okay. I'll
You
just
failed to appear in court 6 different times. You walk in and then you expect the court to drop everything that it's doing because we need to deal with you.
No, I never said none of that. I don't know.
That's the attitude that you've been conveying to the staff and the attitude you've been conveying
No,
to me as we've scheduled this.
Could I
You
go
can
without
stop talking now.
Okay, so you
I'm
can
going to
go
set
off
a personal bond.
You're angry. I'm going to say what I want to say.
Oh, you do
Mr. Talley,
Oh, he needs to stop.
Mr.
Stop.
Talley,
that on your
stop talking. Mr. Talley, you're
I'm
not
in here for
helping
a
yourself.
fucking suspended license, bro. I don't give a fuck about this shit, bro. If you're gonna send me to jail for this shit, bro.
Your bond is $5,000.
Oh, come on. $5,000 for this too, dude. You just fucked up so bad. Thank you for the hype train, everyone.
$1 cash surety.
I'm on like fucking three probation. You think I give a fuck, bro? No, I don't.
5,000 cash surety, no 10%.
No 10%, folks.
$5,000. We're done.
All right.
Did you tell the court officer to make the arrest?
You ever see people just fuck up their life so bad so quickly? Yeah, he probably needs help. He needs a social worker or something. I don't know what's going on, but you don't behave like that if things are going okay for you.
No 10%. Okay.
John Bradley?
There's a
Brad,
bonus.
just need to unmute for me.
Today's theme is don't piss off the judge. That's the theme every day in court.
Mr. Bradley?
Say yes.
Hi.
Hi, Mr. Bradley. Why don't you... Let's see. It looks like you are being charged with malicious destruction of property. Carries a penalty of up to 93 days in jail and a fine of up to $500. Do you understand that charge?
I would just like to say that I'm CAA. And I do understand the charge.
I'm sorry. What did you say?
I'm CIA and I do understand the charge.
He's CIA.
Somebody cut my feet out. Your Honor, somebody cut my feet.
Okay. All right. Well, do you understand the charge?
I'm CIA and I understand the charge.
Right. I don't know what you mean by CIA, but I just got to make sure you understand that charge. It looks like Judge Haley went through it with you.
You don't understand what CIA means. Central Intelligence Agency.
Okay.
This is a mental health issue, I'm guessing.
I guess at this point, I don't really care whether you're CIA or not, but you understand the charge that I'm telling you that you're being charged with?
I do understand the charge and I would like to speak on behalf of myself.
No, don't say anything right now.
I'm not
Looks like
allowed to-
you're asking for, hold on. No, we're not
That's
in.
illegal, Your Honor, if I'm not allowed to speak.
Sir,
for
hold
myself.
on. I don't want you to waive any rights you have, okay? If you're CIA, by gosh, you understand those rights, that's for sure. So let's just kind of get through this together. It looks like you talked to one of the attorneys. It says need video discovery. They're asking for video discovery. So let's just adjourn your matter to.
You can probably produce video of someone posing as me, a CIA disguised artist.
Oh
Find
yeah, definitely mental health issues. That sucks so bad when you get someone in court like this. God, we're just not set up for it very well.
Sure. So we're just going to leave this matter on for a jury trial date, get you a chance to come in and explain all that.
Thank you, Demon Trigger.
For me, okay? Leave on for a jury trial for
You did send that, by the way. I did get that.
January 15th.
I am innocent, Your Honor.
I know, I know, sir. I'm putting it on for a trial on that date. I've entered a not guilty plea, just like they did the last time, okay? But you got to show up for me on January 15th at 8:30. And it's at my court downtown Flint, and we'll send you an order in the mail, okay?
Be careful, my mail gets stolen. It's going to have to be delivered by hand to my body.
I see. Well, we'll get it. It's coming in the mail, so keep somebody.
If I get a chance to explain myself, sir, or somebody else, Somebody,
listen to
somebody
what I'm telling you.
stole my ID and
Okay,
then spray painted down the road and whitewashed it if it's for a whitewash incident.
okay. Are you live on Francis Road?
Now, that was a fib, Your Honor. That was a CA lie.
What address are you at right now?
I'm at 6290 West Francis
Yeah.
Road.
That's what I asked. Okay, so that's where the scheduling order is gonna go. Make sure somebody picks it up for you, okay?
Okay, can somebody deliver that to me by hand?
Well, the post office is gonna deliver it right by hand to your mailbox.
My
So you're gonna
mailbox,
get it.
my mailbox is compromised, Your Honor.
Okay, well, keep watch of it for me, okay?
I'll try.
All right.
If it don't
All
show
right.
up, it don't show up, Your Honor.
Well, write that
made
date
George
down. Sounds like you got help there too. January 15th at 8:15, is that right?
Oh, Dillis Pillar, I think it's definitely mental health. The way he's talking and the paranoid stuff he's saying is very on the nose for, like, some sort of paranoia condition.
Yeah. January 15th at 8:30. You got to show up in person. So somebody write that down for you in case you don't get your mail. Okay?
Okay, to your courtroom, sir?
Yep.
Your Honor?
Yep. Be right in my courtroom.
January 15th at 8:30. Okay, I'll write that down.
All right. Good luck to you.
Thank you, Your Honor.
You're welcome. Bye.
At least it looked like there was another person there with him at the end, so hopefully he doesn't live alone. Let me see what's next. I know it's not a sovereign citizen day, but there is a Sobsit video, so why not?
That right there is a violation of my constitutional rights. I have the rights to see that. The UCC does not pertain to any of your rules or your regulations.
Oh god, his wife looks like you're so full of shit. Oh no.
Or any of that.
All right, this is the District Court of Comanche County, Kansas, case number 25 CV1. Case is entitled American Ag Credit PCA versus Timothy Peterson, individually.
Oh no, it's a credit union. This is going to be another sovereign citizen, I'm guessing, that chooses not to pay their debts, which is never a good idea, but they think they legally don't have to. They're wrong.
And as trustee of the Timothy Charles Peterson Trust, and Shelley Peterson individually as trustee.
Does that flag have a specific meaning? Yes, a lot of sovereign citizens have adopted it because they've been told it's the peacetime flag of America. It's not, but they believe it is, so it's them saying, I'm real America, I'm peaceful, I'm a true patriot, but in a good way, not in a war way, basically.
Trustee of the Shelley Peterson Trust et al. We are set today for hearing on the plaintiff's motion for summary judgment. Plaintiff is appearing through its attorney, Nicholas Grillo. And I believe we have for CNH Industrial, is it Quan Nguyen? Is that right?
Their feed is the new American Gothic.
Yes, Your Honor.
We just need some kind of pitchfork or something to hold.
To make a correction to the record before we get started.
Just finish introducing the case and then we'll take up any issues.
You bet.
And then also appearing, we have Timothy Peterson and Shelley Peterson appearing pro se. All right, so as I stated, we're set for hearing on the motion. So Mr. Peterson, you believe there's some issues we need to address first?
Yeah, I've got a couple, three, Your Honor. Before we begin with my introduction, are we in a constitutional court of record?
I'm not sure I know what you mean.
Are we in the public record?
Yes.
Okay, so therefore this court is a constitutional court of record then. Would you agree?
Well, it exists under the Constitution of the state of Kansas, so I suppose that's correct.
Okay. All right. Thank you, Your Honor. And we are here sui juris, not pro se. And then
it doesn't make a difference. Sovereign citizens like to have specific phrasing, but it doesn't really matter. You're still pro se.
Underneath the UCC 1-308, we reserve our rights under common law without prejudice. And no, Your Honor, we are not the defendants listed upon this court case. We are living souls and living bodies as living people upon the land. And as the sole executors and
Oh, that's crazy. As opposed to me, I live on the sea myself, so it's very confusing seeing all you landlubbers in court.
beneficiaries to the trust listed as the defendants in this case before the court, we are non-corporate citizens. We are U.S. nationals here in peace and non-combative in this constitutional court of record. And we appear only as a special divine appearance to settle the business matters before the court only. And also, Your Honor, as you have addressed, this is a trust issue. The defendants listed here today.
This is not a trust issue. No one said it's a trust issue.
So that was one of the
This is a debt issue.
corrections that we needed to have made that hadn't been previously read into the record. Before we begin, Your Honor, do you have proof of your constitutional oath of office to the people? And do you have proof of your oath of service? Because we require you to be in your oath of the Constitution to the people of service and to your oath of office here.
Does he think he's nailing this? Like, does he genuinely think, like, I'm showing him, this fucking judge, this unconstitutional magistrate?
Today.
Okay. Yes.
Okay. And would we be able to get copies of those? They didn't have that, nor your judicial bond copy at the Comanche County Courthouse.
Someone should gift Ashley a sub. I see everyone with subs except Ashley 1-Up. Someone should gift a sub.
They should. Those were circulated, but I can make sure those are provided to the clerk so you can access them.
Thank you very much, Your Honor. In addition to that,
oh, thank you so much, Sweet Lily Love. That was actually very nice of you. I have power. I said it and a thing happened. I'm gonna get drunk on this power. That's not good.
as we are now
Seriously though, thanks, Sweet Lily Love.
Clearly in the jurisdiction of common law and underneath the Constitution itself, which is the supreme law, well, are you able to uphold your oath to the Constitution, Your Honor?
Yeah, so I've executed my oath, and that's of the record, so I don't know that that's immediately needed to be addressed today. So we do need to get on with the time that the issue that we're set for, which is the motion for summary judgment. So are there any other specific issues before we proceed with that, Mr. Peterson?
Overthought, thanks for gifting a sub to Depraved Ambiance.
This is our private. I would like to know, as these are the defendants, if you can see there, Your Honor, these are the defendants, which is our birth certificates. And also they are our...
I love when they bring their birth certificates to court and try and claim that's them. That's because of the whole straw man thing. I've explained this before, but sovereign citizens believe that the government doesn't have power over you, the person. They have power over what they call a straw man, which they consider to be a fictional paper entity. So they think that your birth certificate, your social security card, basically all of the things that are you on paper, they think that's the thing the government has control over. So that you think you can take your birth certificate to court and be like, this is who you're charging. It's deranged. It's absolutely deranged that they believe this is going to work. The government has power over you. They're the government. It's one of the defining things that the government does. M. Scheffler says, no, you're sober now, no drunk, even on power. Gothgeek Gaming says, when you say you're the babe with the power, you know the power of voodoo. Voodoo, you do. It's a good song.
Minor estate trusts. Does anybody here present today have a higher claim to these trusts and to these birth certificates than we do?
Okay, so we're not going to continue with this line of questioning because it's not relevant to the summary judgment motion. So I think with that, I'm going to foreclose any additional quote unquote preliminary matters, and I'm going to turn it over to Mr. Grillo for any argument on his summary judgment motion. So with that, Mr. Grillo, whenever you're ready, if you have any additional argument, you may do so.
Yes, Your Honor. I appreciate the time and effort, the court allowing us to appear via Zoom. Appreciate the accommodation For the most part, the response, the motion and memorandum in support, as well as the reply, set forth most of the arguments that American Ag Credit would be proffering today in detail. I think that the main thing that I want to point out to the court, and although I'm sure the
guy's
court's
drinking out of a mason jar.
aware of it, in a preliminary matter,
Cups are just a government ploy to steal your identity.
we had a motion for judgment on the pleadings, and that Your Honor ruled on that on June 2nd of 2025 and identified specific issues that remained in the case that were needed to be decided based upon further proceedings. One had to do with whether or not payments or whether there was consideration for not just the original note in August of 2019, but also the renewals that were executed by the Petersons in 2020, 2021, 2022, and 2023, as well as whether or not there was any proof that said that the Petersons have paid American Ag Credit in terms of that in terms of its note and mortgage and security agreement. And Exhibit 6 to the memorandum of support, American Ag Credit produced a verified payment history, or essentially loan accounting for the line of credit the Petersons took out in August of 2019.
I want to know how much it
That
is.
detail in Exhibit 6 shows all the loan advances that were made, as well as all of the payments that were received by American Ag Credit from the time of the inception of the line of credit in August of 2019 through the non-renewal of the line of credit effective on August 1 of 2024. And I think that shows the detail to the court that payments were made, not just from the Petersons to American Ag Credit, but also that loan advances were made to the Petersons throughout the life of the line of credit. And it would be American Ag Credit's contention that shows adequate consideration for not just the original note, but also the subsequent renewals, as well as reflects the lack of payment that was received from the Petersons on American Ag Credit's line of credit.
Brillo needs to spice up his presentation style.
In other words, it specifically addresses the two remaining issues that the court identified and shows that that everything was supported by consideration and that payment hasn't been made. More importantly, there was no contention in response to Exhibit 6, or no affidavit or other material piece of information or facts that were presented by the Petersons in the response to American Ag Credit's motion for summary judgment that shows that there's a dispute in terms of that payment history.
Yeah, objection, Your Honor. They received several negotiable instruments to pay that account in full.
I'm assuming he's doing the Brandon Joe Williams. Brandon Joe Williams is a sovereign citizen guru. He's one of the ones, it could be a variety of people, there's some other ones that do this as well, but he's the biggest one that I'm aware of, where he basically has people create their own money by having these negotiable instruments, because if you don't know, technically cash is a negotiable instrument. So they believe that they can make their own negotiable instruments and pay bills with them. They basically think they can create their own money and then send it to a company and deal with their debt. That's not how anything works. The entire global economy would collapse if that's how things worked and every individual could create infinite money out of nothing. Then money would mean nothing, and it would just collapse everything. So obviously that's not going to work. Brandon Joe Williams is actually in the middle of a lawsuit right now where he tried to pay his electric bill with these bullshit negotiable instruments that he developed. Developed is like way overstating what he did, but he just had his power shut off because he needed them to have the power shut off so he would have damages that he could claim in the lawsuit. So now he's going back to court after already litigating this and having it dismissed because the judge said he had no damages. So now he's wasting even more court time trying to convince people that he can print his own money. It's really absurd. It's crazy. He's also trying to get a case into the Supreme Court. So, jot that down.
And they accepted them, never did return any of those. And by acceptance, therefore, that discharges the liability.
No, it doesn't.
The record, my paperworks are complete with that and has evidence that it's.
And you'll have an opportunity to make your own argument here in a second. So if you'll let Mr. Grillo finish, then I will give you an opportunity.
Thank you.
Well, not in regarding to that, none of that information was presented in response to the motion for summary judgment. No proof was put forth, and I'm very confident that if Your Honor, would review that negotiable instrument that Mr. Peterson refers to, it's not legitimate. It attempts to draw on some sort of Social Security trust on the Treasury of the United States.
Oh, he's doing the different thing. This is actually a slightly different strategy where some sovereign citizens think that they have secret bank accounts with the government that are full of millions or billions of dollars, and they think every United States citizen has this secret bank account. And they think that you can use your social security number to basically draw from that account. So they'll get bills or they'll get fines or whatever, and they'll just like sign them with their social security number and some other nonsense phrasing. And they think that that pays the bill. They'll just pull it out of their secret account. The thing is, there is no secret account. That doesn't exist, and it wouldn't make any sense for it to exist. So you're not doing anything. You're just signing nonsense and sending back the bill.
To pay American Ag Credit the balance of its loan in full. And there's no consideration. There was no money that was going to be paid. It's just not a legitimate argument or payment. And so, but more to the point in terms of the procedural aspect of this case, none of that was presented in their response to the motion for summary judgment. There's no dispute that American Ag Credit maintained a note, mortgage, and security agreement against the assets the Petersons owned. There's no dispute that the loan hasn't been paid, or no proof of a legitimate dispute that loan hasn't been paid, and that American Ag Credit is entitled to a judgment foreclosing its mortgage and security interests in the Petersons' property. As a matter of fact, American Ag Credit set forth 41 statements of uncontroverted fact, and not a single fact was responded to. Not only
American Ag Credit, it's probably Ag Credit as in agriculture. It might be a credit union for like farmers.
It in the appropriate fashion required by the Supreme Court, but in general, there was nothing in the responses the Petersons filed that shows that any of those specific facts were in dispute. And but even then, it's not the court's job to ferret out those items in the record, which is why the rule is the way it has been implemented. And the Petersons were well aware of that rule because they faced the same issue in response to CNHI's motion for summary judgment. So this wasn't a new concept to them, at least in this particular case. And so, Your Honor, I don't see there's any dispute of material fact that exists. I think American Ag Credit is entitled to judgment. There are no affirmative defenses, and there are no issues as it regards to the remaining two items that the court had identified in its ruling that American Ag Credit is entitled to judgment on those issues.
All right, thank you, Mr. Grillo. All right, Mr. and Mrs. Peterson.
Now, they did receive these payments that we sent them, and they were not returned, Your Honor. They
don't have to return them. You sent it to them. They're trash, but they don't have to send them back. You sent it to them in the mail. Do you know how the mail works? Once you send something to someone, it's theirs.
And there are rules and regulations, evidently, that do not apply to the Uniform Commercial Code on negotiable instruments. So their payment was secured. There was no reason to go any further than that. Marbury versus Madison.
We're doing Marbury versus what the fuck? Green guy with a $3 tip says, if I was a secret account, I would act like I didn't exist as well. I'd show no proof of myself, otherwise I wouldn't be secret.
Very clear in its decisions that rules, statutories, rulings of even yourself, Your Honor, do not apply to the people. These apply to corporations and
incorrect
non-legal, non-living entities, dead entities, if you will, Your Honor. They do not apply to us here today. But upon that note, and the word note, we do demand presentation of the original note at this time. We've been asking for the note and has been denied time after time from these gentlemen. It needs to be the original note. It must have the original endorsements, the wedding.
Is he going to say wet ink?
Ink seals.
Yeah.
It must have all allonges or any allonge that attached to it. And if it does not act in their possession, any of these notes, then they have lost the rights to the note, and the note and security follow each other. So at this time, photocopies are not admissible in a court of law. They cannot be used because you
the lawyer's just like, not so sure about that.
Be tried 3 or 4 times for having the same photocopy when in fact they don't have the original. And only
the guy in the top right looks so confused, like he's trying to follow but doesn't know it's horse shit.
The original, and we demand that to be presented at this time.
Did they sign it in their blood? Probably not. Maybe red ink, though. Most of them don't think it literally has to be blood. They think it just has to look like blood, so they'll use red ink a lot of the time. Though there are some of them, a very select few, that do sign their signature with a bloody thumbprint and with blood.
Can be honored, Your Honor.
Is it too soon to muse about who they likely voted for and their opinions on Nasara Jassara? I don't think it's ever too soon for something we already know.
Do you, gentlemen, have the original notes?
Mr. Peterson, we are well beyond any discovery demands at this stage in the proceeding. So I'm not ordering that they're going to be required to produce any additional documents.
Oh, sir. That right there is a violation of my constitutional rights. I have the rights to see that. The UCC does not pertain to any of your rules or your regulations or any of that. It is underneath the common law. Common law states that I have my right.
The UCC is not under the common law. It's statutory law. What are you talking about? It was passed by Congress.
The Constitution. And I am not here underneath the rules and the regulations and the statutory codes of, if anything, in that type of line. I'm here today to get my rights and demands to see that note. If you are trying to subvert the law or correct the law in some unknown manner that is not...
Fuck. My tenant just said that their bathroom is covered in water and I don't have money for a plumber. So that's good. That's good. That's good. Good work.
Been presented to us here today, then that...
I need to start charging this fucker more money. I'm so tired. I give it to him so cheap.
Your Honor, it gives me the right to take that up as a liability against yourself and the gentleman presenting that today. I do have the rights to see those notes. Those notes need to be presented today. I've given them ample time several times, Your Honor, and they accepted that.
Okay. And again, I am denying that request and not ordering that that be produced.
And at that time, Your Honor, can I then object and that you, Your Honor, and the officers of this courts have entered into rights violations underneath the U.S. 18242 deprivation of rights underneath the color of law. May I enter that into the record, please?
Well, I mean, you've just stated it, so I don't need to make a finding. Okay. So, Mr. Nguyen, anything from CNH Industrial?
No, Your Honor.
All right. Mr. Grillo, anything else from you?
Your Honor, the only thing that I would mention is the declaration that Ms. Bailey submitted, verified under penalty of perjury, that American Ag Credit was in possession of the original note, and that it was the holder of that note, number one, and number two, the same Uniform Commercial Code that Mr. Peterson is citing, which is statutory law, not common law.
True.
Indicates that there's a presumption that unless a signature is contested, that they have signed the note and that they are bound by the terms of it. And there's been no contestation under the Uniform Commercial Code or otherwise that Mr. Peterson and Ms. Peterson didn't sign that, the note that American Ag Credit maintains. And so therefore the presumption is, as a matter of law, that
M. Scheffler says he might need some toilet paper to wipe after all the bullshit spewed out of his mouth.
that American Ag Credit has the note signed by the Petersons. And so I think that forecloses any issues that Mr. Peterson raised in his comments.
All right. Mr. Peterson, anything else?
Yeah, that remains in the reverse of what he just said, is wide open. If there remains a note, if it has not been negotiated away by the four banks or whoever they have, then it must be presented. And statutes and codes in the Uniform Commercial Code are actually in place to protect the people from the judges and from the lawyers and such. They are not to be applied to the people. Therefore, I can quote those. And also I can demand those of those people, such as Hinkle Law and Folston Law, and as American Ag Credit, and as CNHI, to present those. If they have already negotiated away those notes, then they've already been paid. Twice, once by me, because the notes were my credit from the start, and the second time through negotiation. If they cannot prove that they have the original note, then they have no honor and no ability to keep asking for additional payments, Your Honor.
All right. I appreciate everyone's argument today. I will take the matter under advisement and issue a written order, much as I did with the same one. So I will review everything that has been submitted of record, both in written filing and here today, and get a written order just as soon as I can. So again, I thank you all for everyone's time. Anything else we need to address before we adjourn?
Your Honor, I don't want to belabor this any more than I need to, but there was at least one other matter that was set on the court's docket today, and it had to do with the Petersons' motion for jurisdictional challenge and a stay pending their attempted appeal on CNH's motion for summary judgment. And specifically, I had filed on American Ag Credit's behalf a motion for additional time to respond to that motion, which was one of the things that was on the court's docket today. The motion was filed by the Petersons on December 4th, which made under Rule 133B the deadline to file a response. December 11th, we filed a motion for additional time on the 10th, asking until December 19th to submit a response, given the gravity of that motion that the Petersons filed. We went ahead and filed our response. So we set this for hearing since there had been no order granting that extension to make sure that that extension was granted and that our response to the motion for stay and jurisdictional challenge it was appropriate.
All right. I have reviewed that motion, and I don't see any reason, and I think there was an objection lodged, but upon reviewing that, I don't think there was any reason that you shouldn't receive the extension. So I will expressly grant the motion for the extension and find that it was timely as filed. So I will take the merits of it into consideration.
Thank you, Your Honor.
And I guess it's probably appropriate, since we went ahead and had argument today, just to rule on the merits of the request for the stay, and the court's going to summarily deny that and will proceed with the summary judgment motion.
Your Honor, I have one more thing before the court.
Okay.
Timothy and Shelley are here peacefully and non-combatively to accept these charges in case CM 2025-000001 on behalf of the minor state trusts, the all capital Timothy Charles Peterson and the all capital Shelley Renee Peterson, that are listed as defendants upon case CM 2025-001, and that are unable to speak as they are legal fictions and creation only. Timothy and Shelley speak for these minor state trusts and living souls with living bodies who have accepted through fiduciary acceptance the right to speak for the defendants and accept, present, and settle all matters before the court in case CM 2025-000001 and in all matters. As Hinkle Law and Associates apparently lacking understand law, Timothy asks that you are addressing the debtor, a secured party, and secured party creditor.
No, this is civil, not criminal. It's over a debt.
As the third party intervener in this matter, the property. We are asking for, we accept all of the bonds that need to be brought before us for the damages that have occurred to us, and we ask for them to be certified, and we asked for them to be claimed by me and held, and then we will turn it over to the court to settle, discharge, or dismiss all charges, and before the matters before the court in honor, Your Honor.
Well, I don't know that any of that changes the procedural posture or any of the arguments for the court's consideration. So I believe I have what I need. Mr. Grillo, just to confirm, were there any other pending motions before the court that I have failed to take up?
No, Your Honor.
All right. Then I will take this matter under advisement and
Oh, well, that's not going to go well for them. All right, I got to call it early. I got to figure out what's going on with this flooded fucking bathroom situation. So I got to get going. Let me see who I'm going to raid real quick. Life is just like shitting on me every fucking day. So that's good. We'll raid Tina too. Have a good night, everyone. I'll see you tomorrow, okay? I don't know what we're going to be doing, but we'll do something. All right, bye, everyone.